Where, in your view, is this actually going to end? It has extended for a while. There are other social media and tech companies that have complied, but have, public reservations about the laws and its provisions. Twitter is one company that has not complied with the laws so far. How do you see this actually playing out? Because it appears to be escalating, and people are left wondering, how is this going to end?
Well, if Twitter continues on the path that it is, then it is not going to end well for them, because Twitter stock has already lost over 25% in the last few weeks since the issue of compliance with Indian regulations has come to the notice of the market and the investors.
Yeah.
And Twitter should, in fact, learn some lessons from TikTok and PUBG and the likes, who we banned for security concerns, that defiance has a cost. And particularly if you are talking about a market that is as large as ours, clearly the investors would have a lot of questions to ask the Twitter management. And therefore, to answer your question, how is it going to end? I think I've given you the road ahead.
Are you saying banning Twitter is easily one of the visible options if they continue to show defiance? I just want to be clear, because there are millions of Twitter users. That's why I'm asking.
I am giving you the answer. The answer lies between the conversation that Twitter's investors would have with their management. Okay.
Rahul, as we wind up this discussion, that's what I want to ask. I want to ask on behalf of people out there. We've had the legal discussion. We've spoken about this particular incident. The way you see this actually playing out, not an exaggeration to say that it is escalating. Do you see the possibility of some kind of adverse action against Twitter if it doesn't, stop this quote-unquote defiance?
Let me put it like this. If Twitter doesn't follow the intermediary guidelines and a court so holds, as per Rule 7, they lose safe harbor protection, that's it. That means they can continue to be in India, but they'll be liable for whatever anybody else puts forward. I think as a practical matter, no intermediary would like this, so they would probably exit. As far as exiting it otherwise is concerned, then the government of India can take a call if they want to throw out Twitter and lose millions. And I think most of our politicians have millions of followers on it. So I don't think it's really on the cards. So they may want to hector it as much as possible and try to influence it in whatever ways. But I really don't them throwing Twitter out. But listen, before you go, can I just make a couple of points? I was interrupted last time.
Yes.
Firstly, like I was saying, as far as copyright is concerned, Ms. Nabina may have a different view, but as far as I see it, I don't think intermediary guidelines override the copyright guidelines, because the copyright law overrides the IT Act. That's the first part. Secondly, copyright is different from everything else for the simple reason, like I said, the example I was giving you, that if, for example, a movie is released tomorrow, you need an order immediately. You can't wait for a court order to take down a movie. If tomorrow millions of rupees will be lost unless this is done immediately. So this is the process for that. As far as the US digital the act is concerned, a complaint was made under that act. That means the creator of the content, whatever it is, made a complaint under American law. And the most interesting thing about this is that the blocking was only for roughly about 1 hour. Okay. What does that mean? It means to me that this was obviously done by artificial intelligence. The same artificial intelligence which the rules say that you should take down all kinds of other stuff like pornography, etc. This goes on to prove that unless there's a manual override somewhere, automatic censoring is probably not the best or the wisest thing.
Okay.
And as far as Article 19 is concerned and the argument, Article 19 1A applies to the government of India. It doesn't apply to private enterprises. Private enterprises governed only by the regular law of the land.
Okay.
And there is no law that says that they should do this anyway. It's a matter of good business practice. But frankly, the obligation to obey the constitution is on the government, not on private companies.
Ms. Napana, I saw your hand raised. So before I go to the others, let me come back to you if you want to rebut. And also the question that I'm asking, where do you see this finally ending? Is it going to be an extended sort of season of exchanges between the government and the, and Twitter? And I'd like to ask that direct question. Is banning Twitter or some other adverse kind of action against them a possibility?
I don't think that would be a good idea at all. Even if it is, I believe it's not possible, because we are all dependent on platforms irrespective of where they're emanating from.
And the reason I ask is because apps have been banned. Less than a year ago, big popular apps have been banned in this country. That's why.
True. And therefore, that's why I said I hope that's not going to be the extreme action in this case. And in terms of your question about where do you see this going? See, this is not just about Twitter. It's about any social media platform or other microblogging sites like Twitter, etc. We need to really draw the line here and understand what we are talking about here. We are talking about complying with the rule of law in India. And that is something that has to be understood as being sacrosanct and complied with, and any kind of contest or protest that any platform may have will have to be taken into account as per due process. The aspect I wanted to come in on, where I had put my hand up for the intervention, is unfortunately Rahul is reading the law wrong, because a heading says overriding does not mean that's what the provision says. The provision says that the Information Technology Act overrides, supersedes everything else, and gives a proviso saying, however, the provisions of Copyright Act will also apply, which means you may take your remedy under the takedown provision of the intermediary guidelines, or you may resort to the takedown provisions under the Copyright Act. But the point I was making earlier, and I reiterate now, is we are speaking about the application of the Indian law here. Unless and until it can be shown that the content was amenable to, the victim was amenable to US laws, and therefore extraterritorial jurisdiction is being applied, to do so blindly, irrespective of whether it's through automated tools or otherwise, is incorrect. And we cannot draw comparisons of apples to oranges here, of equating use of automated tools for combating child sexual abuse content or violent videos against women with copyright content, because automated tools were implemented way before the Prajwala order or the intermediary guideline. So when it chooses, when they choose to, they are using automated tools. When they don't, they raise this issue of free speech. And I know you're running out of time, but I'm shocked at this statement made about corporates or others not being amenable to fundamental rights of free speech. I'm really concerned on that statement.